The proposed Electoral Amendment Bill has been met with scathing criticism. Civil society organizations have now launched a campaign against the bill. The group includes the Ahmed Kathrada Foundation, Defend Our Democracy, and Rivonia Circle. They say the bill disadvantages independent candidates, among others. Perhaps let's just get now a perspective on this. I'm joined by Lawson and Naidoo. He's the Executive Secretary of the Council for the Advancement of the South African Constitution. That's CASAC for short. Lawson, good afternoon. Welcome to today. Thank you very much for joining us here this afternoon. What is it about this bill that is unfair?
Good afternoon, Dan, and thank you very much. Well, if we cast our minds back, this bill has come about as a result of a judgment of the Constitutional Court in the New Nation Movement case a couple of years ago. And the court ruled that the current electoral system is unconstitutional to the extent that it does not allow independent candidates to contest national and provincial elections in the same way that they are able to contest awards at a local government level. And the bill that is on the table seeks to tweak and do no more than that the current party list system and simply says that independents can stand and contest the list system alongside political parties. So as an example, a whole province will constitute one constituency, and within that provincial boundary, independent candidates will be up against political parties. And the formula that is used to calculate the number of seats allocated means that independent candidates would require far more seats than a political party to secure a seat, and that's why it's inherently unfair. But, you know, when one looks at other parts of the bill, it also becomes very apparent that this model that has been chosen is totally inappropriate to accommodate independent candidates. And what really needs to happen is for some form of constituency system, be it a single-member constituency system, which was in fact recommended to government by the Ministerial Advisory Committee that had been chaired by former Minister Vali Musa, or a multi-member constituency system, such as that proposed by the Van Zyl-Slabbert report some 20 years ago. But Parliament and government have opted for neither of those options and have sought to do almost the impossible by trying to accommodate independent candidates in this current bill, which is clearly not fit for purpose, is fundamentally flawed and more than likely unconstitutional.
So what I'm hearing is, while it's an amendment bill, it does not go deep enough, it does not go far enough in terms of addressing the participation in the upcoming 2024 national provincial elections of independent candidates. In fact, they'll be at a huge disadvantage because it applies a formula about numbers. So if you are bigger and you are more organized, you are likely to have an advantage. If you're independent, of course, you are on your own, you're going to be at a huge disadvantage.
Well, yeah, I mean, that sums it up very neatly, Dan. Just to give one more example, you know, in terms of the eligibility criteria, independent candidates will be required to get anything between 8 and 15 to 18,000 signatures before they can even appear on the ballot paper. That's hugely unfair because political parties only need to provide indications of support when they register with the Electoral Commission as a party, and there they require 1,000 signatures. And come election time, parties are not required to do anything further. So this places a further unreasonable burden on independent candidates. It'll cost them a significant amount of money to do the work to secure those signatures, and therefore puts them at a great disadvantage vis-a-vis political parties. So that's just another example of why the current bill, as it is framed at the moment, is inherently unfair. And we've got to have a level playing field. And ultimately, we have got to create an electoral system where each vote has equal value. In the model that's being proposed at the moment, that is not the case. It offends against the principle of proportionality, fairness, and a range of other aspects. And, you know, there have been several calls over the years, from the time of the Van Zyl-Slabbert task team until the Zondo Commission report most recently, that have called for some kind of constituency system, because the fundamental defect in our politics is the lack of accountability. which was, very clearly demonstrated in the Zondo Commission hearings. And this is an attempt to try and do that, or should be an attempt to try and do that. Yet what we see are political parties, and it's notable that all of the political parties represented in Parliament are quite happy with what is on the table. And the reason they're happy with it is it leaves power in the hands of party bosses and means that MPs are ultimately responsible to their political parties rather than to the electorate to put them there.
Yeah, I'm told that a constituency-based system brings accountability closer to the voter in terms of the public representative. Now, Parliament, Lawson, has until December. We're not far away, about 2 months to go to finalize the bill. What do you plan to do? I mean, we understand that you've got a number of civil society organizations. I know you don't speak on their behalf. I don't know what they are planning to do. The likes of Ahmed Kathrada Foundation, Defend Our Democracy, and Rivonia Circle. What do you think should be done between now and December as you raise the issues of the unfairness of the bill that's before Parliament?
Well, let me start, Dan, by saying that it's because of Parliament that we find ourselves in this position. Parliament has already failed to meet a deadline that was set by the Constitutional Court. This legislation should have been finalized already by June of this year. They failed to do so, partly because the minister only introduced the bill into Parliament in January this year, 18 months after the judgment of the Constitutional Court. So the rush timeframes are due to Parliament's own fault. And the court has now given Parliament a deadline to the 10th of December to amend the legislation. But unfortunately, we now face a crisis, because if this legislation is either not passed in time, or secondly, even if it is passed and passed largely in its current form, it's likely to be the subject of a legal challenge from some court or another, whether from civil society or elsewhere. And that would necessitate a further delay. And that then puts the 2024 elections under some risk. And the responsibility for that has to lie firmly at the door of Parliament.
Thank you very much for your time. That's Lawson Naidoo. He's Executive Secretary, the Council for the Advancement of the South African Constitution. Still